my name is Alicia Birach, and I am a partner practicing primarily in the area of workers' compensation defense. So what that means is I represent employers, insurance companies, and self-insureds when an employee alleges they were injured on the job site. I also handle some coverage issues in addition. So this morning, we're going to try and make up for some lost time. So I'm going to be brief in my presentation, but I do want to cover two primary issues that are relevant to employers and that we're receiving quite a few questions on right now in the workers' compensation realm. The first being the impacts of remote work. Fortunately, it appears for the most part, we're on the other side of the COVID pandemic. And with employers returning to quote unquote normal, there are some changes that appear here to stay, namely remote work. Many employers have opted to either allow employees to remain fully remote or have created hybrid work policies where the employees are allowed to work, partially from home and partially in an office setting. And as Matt mentioned earlier, that has a lot to do with recruiting talent and maintaining talent. And so for a lot of employers to remain competitive, remote work is a reality that we're all going to be dealing with for the foreseeable future. And so what sort of issues has that created from a workers' compensation perspective, and how do we manage those, and what should we be on the lookout for? And then in addition, one of the questions we've gotten regularly throughout the years from employers is, how do I impact my premium? How do I reduce my rates, and how is my rate calculated? Particularly with the fact that most workers' compensation claims do settle. And a lot of employers ask when we reach out to them for their employer's consent, well, how is this going to affect my premium? How is settling this claim here today going to benefit me or hurt me? So I wanted to sort of touch on both of those issues. So moving into remote work. So the first thing to consider is, has the employee's home become his or her work site? And when you're evaluating whether or not that's the case, the quantity and regularity of the work being performed at home, the continuing presence of work equipment at the home. So do they have monitors and printers, a phone system, whether there are special circumstances of the employment that made it necessary, not just convenient, for the employee to be working from home. In cases where you have a policy that designates they are allowed to work from home either full-time or on a hybrid basis, that's likely that the work site will be, considered the home as well as the office, particularly because a magistrate will evaluate the situation and see that there is a benefit to the employer of having the employee working from home, namely, as we already kind of touched on, from a recruitment perspective. And so in many instances, the employees that you do have working from home, the work site will include their home. So what happens when the home is part of the work site? Well, basically the risks associated with the home now become the risks associated with the work site. So, the most common example used is they have Fido the dog who resides with them, who obviously would not likely be at your office. And Fido the dog, is laying on the floor, and your employee gets up to run to grab a coffee or to use their restroom and trips over the dog. Is that compensable? And since Fido the dog is now a risk associated with the work site, and what they were doing was incidental, grabbing coffee, using the restroom, it likely would be covered. And so the difficulty to employers with this is that you've lost the ability to sort of manage some of these risks and implement safety measures. Some of the things you can still do, especially when we're talking, a lot of these employees who are remote are office employees. You can still work to provide, ergonomic work sites, including, chairs, keyboards, and different things that you would do in the office. You could provide similar equipment at home to try and mitigate some of those risks. But with respect to, whether or not they have a dog or how tidy their house is or how well, they're keeping their sidewalks cleared from ice, those are things that you'll no longer be able to control. So if an employee, who's hybrid and leaves a folder in the car, runs out to grab the folder and, trips on their sidewalk, now you have an issue whether that's potentially compensable. So what's covered and what's not covered? Activities that are incidental to the employment are going to be covered. So if someone, like we said, is injured when running to grab a cup of coffee or running to use the restroom, that's going to be covered. The question kind of becomes more blurry when the individual is mixing personal and business use. So obviously, when you're in an office setting, you can't run down to switch out your laundry, but you can when you're home. Is that incidental, or is that too great of a deviation from the employment to take it outside of the realm of a work-related injury? So, there's a lot of gray area with theirs. You're running down just to quickly switch your load, and you trip on the stairs. That's definitely a gray area where you're going to have to really dig into those facts. And versus a situation where someone hops on their treadmill to take their conference call while they're working. Arguably, that seems like too big of a deviation, the pursuit of which is more social recreational. You're obviously getting in a workout. So if you hurt yourself on that treadmill, you have a much stronger argument that was not incidental to the employment and that was too great of a deviation. Likewise, if you walk down the street to the local cafe and trip on your way, that's the purpose of that is social recreational, and that appears to be too great of a deviation. So it's going to be a very fact-intensive analysis. The more facts you can get from the employee, the better. The most important information to gather at the time of the injury is the time, place, and circumstances of the injury. So make sure it occurred during the working hours. Did the injury occur in their designated workspace? Was it in the office setting that they use, or was it somewhere else within the house or on the property? Whether they were engaged in work at the time of the incident, or again, were they deviating from the employment? Were they grabbing laundry? Were they getting a coffee? What were they doing specifically? And whether or not the activity was prohibited by the employer or so remote from the customary practices of work that it constituted a complete departure. Obviously having policies in place about what they can and can't do during those work hours when they are working remotely will help protect you and mitigate your exposure. The other thing, and one of what I'm finding to be the more important things for employers to keep in mind, is do you have the appropriate coverage in the appropriate states? What's happened is when employees went remote, they were here, they were working for a Michigan company, so they were living here in the state, and then COVID happened, and they decided, hey, this is a good opportunity to move home to Florida or Colorado or wherever they're from, because I can do the job just as easily in my den in Colorado as I can here in Michigan. And so off they go to Colorado. Well, what is the coverage threshold in those states where your employers are working remote? So for instance, here in Michigan, if you have one employee who's working 35 or more hours a week for 13 or more of the preceding 52 weeks, you would be considered a covered employer. And so, if you have an employee who's in Colorado, you need to know what their coverage thresholds are and determine whether you meet those thresholds and make sure you're properly insured and have coverage in the states where all of your remote employees are working. So that's very important information to make sure you are getting, and a very important thing to evaluate so you're not getting hit with fines and you're not left defending a workers' compensation claim out of state when you simply don't have coverage. So moving on from remote work, the other thing I kind of want to touch on is premiums. How are premiums set? There's designated data collection organizations in the state that establish the manual rates for job classifications. Most states use the National Council on Compensation Insurance. Michigan is not one of them. We are one of 11 independent data collection organization states. The Compensation Advisory Organization of Michigan is the data collection organization that we use here. So the manual rates for each classification code will vary by state because of differences in laws and benefits. The manual rate is a specified rate that's established by classification code for every $100 of payroll. So what that means with respect to classification codes is they lump different job types together. So if you're a framer, for instance, on a construction site, or a plumber, those are going to be different classification codes, and those are going to have a different rate assigned to them. The manual rate is multiplied by the employer's payroll to establish the manual premium. So if the manual rate for a framer is $5 for every $100 of payroll the employer has, if they have $100,000 in payroll, the annual premium would be $5,000. So it's just a simple mathematical calculation. The manual premium is then adjusted by other factors, including the employer's experience modification, to determine the annual premium. The basic premise of experience modification is actual loss versus expected loss. And this is really where you can, focus some of your efforts in terms of trying to manage costs. It's important to understand that primary loss has a bigger impact on modification than excess loss. So that means, the first portion of loss on the claim, it's going to hit you 100%. And so if you have five $5,000 claims, all 100% is, being attributed to you, you're going to have a higher experience modification than if you have one $100,000 claim, because only that first, $5,000 hits you 100%, and then to a lesser extent for the next portion, and for the end, there's a portion that doesn't even hit it. So that's something to keep in mind. Why this is relevant is because if you have an employee who's injured, let's say back in 2010, they hurt their right knee. They have some issues, they treat, they come back to work, and then, 2020, they come back to you and say, hey, my right knee's hurting again. You really want to dig in and see if there was a new injury, or if it relates back to the initial claim in 2010. If it relates back to the initial claim in 2010, this is to your benefit, because you've likely already used the primary loss portion. And so any ongoing expenses will have a much lesser impact on your experience modification. So when someone comes to you and says they were injured, really take a look and determine if it's in fact a new injury, or if you can relate it back to a prior claim. And that will benefit you and try and, when you're trying to keep your premiums down. The other thing to keep in mind that you can do when trying to keep your premiums down is medical only claims only impact you 30%. And so the reason sort of behind that is, they view it as beneficial to bring employees back to work. So if you can keep an employee working, it's only a medical only claim, it will impact your rates to a lesser extent. So that is something else you can do. The other thing that, I would point out is that when you're sitting here in 2022 calculating your premium for 2023, they're going to look back at 2021, 2020, and 2019 and doing that calculation. So keep that in mind. And so again, if you can relate that knee injury back to the 2010 claim, that's not going to affect you in 2022 when calculating your 2023 premiums. So that's something that really can benefit employers in terms of managing costs. And last but not least, your incurred costs are both what is reserved on the file in addition to what's already been spent. So when we're talking with employers about settlement and a case is reserved for $20,000 and we can settle it for 10, that can actually benefit the employer and help reduce their experience modification and premium moving forward, because we're settling it for less than what the incurred cost is reserved for. So that is something else to keep in mind. Obviously, I could talk about this for hours and hours, and you might have questions, so feel free to reach out to me separately or when Mike and Cliff are done speaking. But at this point, I want to hand it over to Mike to introduce him and Cliff and discuss labor issues. Thank you.